Okay, we're all present in the counted form. I'm pleased to open up the morning session. After yesterday's very interesting overview of many issues concerning consent and access, we have three speakers in this panel. I'm going to try to be strict. My main function is to keep everybody to 20 minutes, so we have some time for questions. And we are already starting late. So I'll have my equipment here. And I'd like to introduce, but Daphne, if you don't mind, Lance has suggested that they precede you and you speak last. Is that okay? So this is what we'll do. Our first speaker will be Lance Bartholomew. He's the acting director of the Legal Affairs UN Relief and Works Agency, UNRWA, for Palestine. Sorry, for the Near East. UNRWA operates in Syria, Lebanon, Jordan, the West Bank, and the Gaza Strip. Lance holds a Bachelor of Laws from the University of Queensland and a DEA in International Relations, specializing in international law from the Graduate Institute of International and Development Studies in Geneva. He's published in several areas, including on amicus curiae in international courts and tribunals and the mandate of UNRWA. So I turn the platform over to Lance.
Thank you. Let's see if that works okay. Great. Okay, today I'd like to make some remarks on UN cross-border humanitarian assistance. Now I realise that there'll be many speakers afterwards who are going to touch on some issues. So where that happens, I'm going to just make very brief remarks so that we don't all repeat each other and you get really bored with the 7th reference to necessity and countermeasures in the Nicaragua case by 5:30 this afternoon. So during the current Syria armed conflict and prior to Security Council Resolution 2165, the UN had not engaged in cross-border assistance without the consent of a state. Now, a group of distinguished international lawyers has openly criticised what they perceived as an unduly conservative interpretation of IHL by the UN that, according to them, has held the UN back from cross-border assistance without consent of a state. An overview. My thesis is that IHL is not the only relevant legal framework when it comes to the UN. To determine what the UN may or may not do when there is a violation of IHL, we also have to look at the law of state responsibility, and we have to have a look at the UN Charter, the UN's practice in accordance with the Charter, and also the Secretary-General's duty of care towards his staff. In my view, the privileges and immunities of the UN under the UN Charter and the 1946 Convention on the Privileges and Immunities of the United Nations are a stronger, more credible legal basis for cross-border assistance than IHL. And in any event, international law is very useful to support interventions to persuade states to consent to cross-border assistance. So I'm going to discuss legal issues today, but since the topic of our conference is also legal and operational challenges, I also want to just preface this with a little bit about the context for a practitioner such as myself working for the agency I work with. So I work for an operational UN humanitarian agency that works in Syria, Lebanon, Jordan, West Bank and the Gaza Strip. For us, humanitarian action is an imperative. It's not an option. And my role as a lawyer with the agency is to help facilitate access and not to block it. So I don't want to be perceived with my comments as just negative, negative, negative. We have to make access happen. I've never won an access argument in the 10 years that I've been with UNRWA working in this area purely on the law. A firm basis in international law must be combined with persuasive humanitarian, political and security arguments. And a practitioner seeking access must be credible and pitch the interventions to the audience. Now, here it's great, we have an audience of international lawyers, but this is not the usual audience for a UN practitioner. The audience that we will often be speaking to are security, intelligence personnel, and sometimes, if we're lucky, international lawyers in the Ministry of Foreign Affairs and in the military. So we have a broader audience, and some of them don't know much about international law, or if they do, that's not their prime consideration. So moving on to the law then, I'm going to make a number of assumptions, again, just so that I can touch on the essential parts where the UN is concerned with cross-border relief operations. Now I'm going to assume here that when there is an arbitrary withholding of consent to an offer by the UN for a cross-border relief operation by a state, that's a violation of IHL. First thing. And that's something that, again, the Security Council noted the Secretary-General's view that this was the case in relation to Syria when it passed Resolution 2165. So if we have a violation of international law, then what are the legal consequences? Now, here I turn to the distinguished lawyer's letter, which was published in The Guardian in 28th of April 2014, to see what they said. They stated that the appalling situation in Syria, and here it is truly appalling, hundreds of thousands of, well over 100,000 civilians killed. The lawyer stated, has been compounded what we deem to be an overly cautious interpretation of international humanitarian law, which has held UN agencies back from delivering humanitarian aid across borders for fear that some member states will find them unlawful. The lawyers concluded, where consent is withheld for arbitrary reasons, the UN relief operation is lawful without consent, and that in the case of Syria, UN agencies and other impartial aid agencies that are willing and able to undertake cross-border actions can lawfully deliver life-saving food, water and medical assistance to desperate women, children and men inside Syria. Now, in my view, it's questionable to conclude this way in respect of the UN without also referring to the law of state responsibility and to the UN Charter. Let's turn to state responsibility. Normally, if there is a violation of international law, there will be an internationally wrongful act. What does that mean? That means, amongst other things, that the state, the wrongdoing state, has an obligation to cease the act if it's continuing. So to cease the withholding of arbitrary consent, and also to give assurances of cessation and of non-repetition. There's also an obligation to provide reparation, which could include compensation or satisfaction, an apology. Now here I'm assuming that an international organisation such as a UN agency who's offering a relief operation is an injured international organisation, then there would be the possibility under the law of state responsibility, law of international responsibility, for the international organisation to demand cessation, seek assurances of cessation, guarantees of cessation and non-repetition, and reparation. But under the law of state responsibility as set out in the ILC articles, you don't see a legal consequence being that the injured international organisation or state can treat the situation as if the internationally wrongful act did not occur. That's state responsibility. We'll come back to that in a little moment. First of all, what are the principles of the UN Charter and the key decisions passed by UN political organs in accordance with the Charter that either restrict or guide the UN's ability to engage in cross-border operations without consent? Before going to that, we've heard from the lawyer's letter of 28 April 2014. Let's hear what the UN responded to the lawyer's letter. It was during the Secretary-General's spokesperson's remarks the following day in response to a question from the gallery. So the official UN position was stated, 3 points were made, and some of these won't be surprising. One, the primary responsibility for the dire humanitarian situation in Syria lies with the Syrian government and other Syrian parties. One. Secondly, it's the long-standing and consistent position of the United Nations that, consistently with its charter and the decisions of its competent intergovernmental bodies, The organisation can engage in activities within the territory of a member state only with the consent of the government of that state. So here is a very clear declaration of UN position and practice. The only exception, they went on, is where the Security Council has adopted a binding resolution under Chapter 7 of the Charter authorising the organisation to act without the government's consent. Now, the UN did not state precisely which provision of the Charter or decisions of the organs underlay its long-standing and consistent practice, but its statement did make clear, by what it didn't refer to, that the interpretation of IHL was not really the issue. When we have a look at the UN Charter, there's, in its purposes in Article 2, there's two possible articles that we could refer to. One is Article 2.1, which is the organisation is based on the principle of the sovereign equality of its members, and the other one is Article 2.7, which is that nothing contained in the present Charter shall authorise the UN to intervene in matters which are essentially within the domestic jurisdiction of any state. This principle shall not prejudice the application of enforcement measures. Now let's just have a quick look at both of them. Now, Article 2.1, what does that mean? Now, when we refer to sovereignty, you know that yesterday evening there was a discussion about sovereignty. Now, sovereign equality under the Charter, it is not just an airy-fairy concept. There is content to it. And for a guide to the content, we can go to the authoritative statement of the General Assembly in the 1970 Declaration on Principles of International Law concerning Friendly Relations, etc., etc., where the General Assembly stated that sovereign equality included the element that the territorial integrity and political independence of the state are inviolable. This is much more concrete than just a statement of sovereign equality. Now, Article 2.7, I think we can dispense with pretty quickly. I know that it's something that Andreas will touch on in his presentation, but really the scope of what is essentially within the domestic jurisdiction of a state has become much more constricted since when the Charter was first enacted. And so I think that since the Security Council considered itself able to pronounce on humanitarian assistance by the UN and others to a state involved in a non-international armed conflict, even before 2165, Article 2.7 is not really a good basis for the long-standing and consistent position of the UN that you act with the consent of the state. So I think we'd be hanging our hat on Article 2.1 of the UN Charter. Let's have a look, though, at another important decision, which in effect set up the Emergency Relief Coordinator and is where OCHA finds its roots, which was General Assembly Resolution 46182 of 1991 on strengthening of the coordination of humanitarian assistance of the United Nations. It was adopted by consensus, very important, after lengthy negotiations conducted by the current Deputy Secretary-General, Jan Eliasson. So this is not your normal resolution. It annexed important guiding principles on humanitarian assistance. Principle 3 states the sovereignty, territorial integrity, and national unity of states must be fully respected in accordance with the Charter of the UN. In this context, humanitarian assistance should be provided with the consent of the affected country and in principle on the basis of an appeal by the affected country. Now, there's some who might say, well, it used should. That means it's not mandatory. But I would suggest that the word should had to be used because there's always the possibility of a Security Council Chapter 7 decision. There's also, we need to bear in mind the context of the consensus, and we see, for example, the statements of Uganda after the adoption of this, where they underlined that the basis of their joining in the consensus was that the notion of sovereignty of states must be fully protected and respected at all times in responding to emergency assistance, and their consent must always first be obtained. Now, we could also refer to the Nicaragua case that's already been spoken about last night, so I won't dwell on it too much here to say that it is problematic when it comes, when we are looking at its applicability to UN humanitarian operations. It was dealing with the principle of non-intervention, which the ICJ explicitly said was not as such part of the UN Charter. I also wonder whether it's one of those findings of the ICJ, and particularly in the Nicaragua case, that are part of the law, but are not really part of what states embrace. A little bit like Nicaragua's statement on self-defense and the scope of that. The responsibility to protect, I just want to pass on that because we don't have a lot of time, but just to say that the way that the responsibility to protect, I think the way that it's formulated in the Millennium Outcome of the General Assembly of 2005 doesn't really assist us, because it's talking about collective action really through mentioning the Security Council. So I think it's not particularly helpful there. If the United Nations did breach the Charter, there's possibilities that there could be circumstances precluding wrongfulness. Necessity and countermeasures come to mind. That'll be dealt with more ably than I will be able to by Françoise, I think, later on in the day. So I won't give too much of an opinion on that, other than that I would doubt that those would apply except in extremely limited circumstances, perhaps for necessity, more later. What are the other UN-specific considerations? Now, many people know that there is a risk in operating in Syria. Now, the safety and security of humanitarian workers. Let's be clear that in practice, acting without consent means acting without cooperation or coordination. And this can and certainly would result in a grave impact on the life and security of humanitarian workers. Experience has shown from operations in Syria and elsewhere that even with the best cooperation, humanitarian workers still get shot at. This is a very important thing to keep in mind as part of the operational challenge, but it does have a legal aspect for the United Nations, and that is that under the UN Staff Regulation 1.2c, staff members are subject to the authority of the Secretary-General and to assignment by him or her to any of the activities or officers of the UN. In exercising this authority, the regulation goes on, the Secretary-General shall seek to ensure, having regard to the circumstances, that all necessary safety and security arrangements are made for staff carrying out the responsibilities entrusted to them. If there is a breach of that, then staff members can have access to the various tribunals of the UN to seek recourse against that. Now, coming back to what I mentioned at the outset, that in my view for the UN, and something that we advise within, at least in our UN agency, and when we've been feeding into the Interagency Task Force on Syria, IHL that we're discussing, there's some fancy concepts in here, quite contested. We think actually that the boring 1946 framework is something that provides a stronger framework. We often refer to Article 2.5 of the UN Charter, which provides that all member states should give the UN every assistance in any action it takes in accordance with the Charter. Now, cross-border relief is really the movement of goods and people from State A to State B. Just very quickly, here I want to mention 3 parts of the 1946 Convention that specifically relate to that. One is under the 46 Convention, which has 160 parties and no reservations to any of the provisions that I'm going to talk about. And we have parties like Syria, Iraq, Turkey, Jordan, Israel, so very well signed up to, unlike AP2, for example, or even AP1. One of those is that the UN is exempt from all prohibitions or restrictions on imports or exports of articles for its official use. So that's a very important one. Secondly, the property and assets of the UN shall be immune from search, requisition, confiscation, expropriation, and any other form of interference, whether by executive, administrative, judicial, or legislative action. And thirdly, in relating to people, slightly weaker protection, but still quite strong, is that United Nations officials are immune from immigration restrictions and alien registration. And if you're a holder of a UN laissez-passer, so one of those, if I rock up to the border, or a blue one, if you've got one, we are entitled to speedy processing of visa applications as a holder of the UNLP, and also to the provision of facilities for speedy travel. And in the practice of the UN, being refused entry is not considered to be speedy travel. unsurprisingly. So, in conclusion, I think that there's not currently a solid, credible legal basis for the UN to engage in humanitarian assistance without the consent of the relevant state, unless there is a relevant, let me say, binding and/or Security Council Chapter 7 Council resolution, so that I can preempt my colleague Andreas before he comes. And really to say that, really just to finish, law is useful, but I think in practice, humanitarian access, as my operational colleagues, some of whom are here, will attest. When you have a look at UNRWA's access to Yarmouk camp in Syria, for example, which was quite something, I would like as a lawyer to claim a large part in that access. Unfortunately, I can't. And the reason for that is that this kind of access is achieved mainly by patient diplomatic negotiations, especially at the local level, with an ever-changing cast of non-state actors and states where the different ministerial officials will have very different views and interests. And that is really where the issue is. International law is useful to support efforts to obtain consent for relief operations, but it cannot be counted upon to fill all the gaps where diplomacy fails. Thank you for your attention.
Thank you very much, Brian. A very lucid presentation and for keeping to your time. Our next speaker is Professor Andres Zimmermann, Professor of the University of Potsdam and Director of the Potsdam Center of Human Rights. He's a graduate of Dr. Juris from Heidelberg and an LLM of Harvard. Advisor of German delegation to the United Nations Diplomatic Conference on the establishment of an international criminal court, member of the Permanent Court of Arbitration, counsel in various cases before the ICJ, and I will leave your distinguished credentials there at that point.
There are no more, anyway. Okay. Thank you, Mr. Chairman. It's a real pleasure to be here at this conference, and it's also an even more pleasure to be here at Hebrew University for a somewhat prolonged period of time. I truly appreciate it. I was tasked to speak about humanitarian assistance and the Security Council, which in light of Security Council Resolution 2165 is obviously a most relevant issue. What I will do is I will first outline with a rather broad brush the practice of the Council when dealing with humanitarian assistance. I will then address somewhat more general legal issues related to the Council's practice. I will then move on to 2165, and then we'll ask, what does 2165 tells us about otherwise applicable rules of IHL? Now, looking at the Council's practice, it is rather broad, and if we only look at the practice since 1990, it started with northern Iraq, where the Council, quote, insisted that Iraq allow immediate access by international humanitarian organizations to all those in need of assistance in all parts of Iraq, end quote. And the same was true with regard to Bosnia, where the Council, even without invoking Chapter 7, quote, called on all parties and those concerned to ensure humanitarian assistance being brought in. And that was reiterated by the Council with regard to Armenia, Georgia, Rwanda, Afghanistan, Yugoslavia, Kosovo, and so on and so forth. However, it was only relatively late that the Council also invoked Chapter 7. Lately, for example, it started in Bosnia, but lately with regard to Libya, where acting under Chapter 7, the Council, quote, demanded that all parties and others concerned create immediately the necessary conditions for unimpeded delivery of humanitarian supplies. And then, in its more recent practice, it included in the mandate of peacekeeping operations, Chapter 7 mandate to also, quote, ensure the safe delivery of humanitarian assistance. Or, in the case of Libya, provided for a flight ban acting under Chapter 7, quote, in order to constitute, which in the view of the Council, constituted an important element for the safety of the delivery of humanitarian assistance. So there is abundant practice by the Council in various aspects, both under Chapter 6 or under non-Chapter 7 and under Chapter 7. And it's in light of this practice that I will now consider some of the more general issues, starting with 2.7 of the Charter, to which Lance already alluded to. And indeed, I can be, just like him, be brief that as we all know, ever since the famous dictum of the Permanent Court, that, quote, the question whether a certain matter is or is not solely within the jurisdiction of a state is an essentially relative question. It depends on the development of international relations, end quote. That was the Permanent Court in the 1930s in nationality decrees in Tunis and Morocco. And we all know that the issue of humanitarian relief has become a matter of international law. It has been dealt with in AP2 and in other treaty norms dealing with the matter. And even more so, the ILC is dealing with the protection of persons in the event of disasters, including humanitarian relief, even in non-armed conflict. And a fortiori, then humanitarian relief in armed conflict is no longer to be considered to fall within the domestic jurisdiction of a given state. And besides, even the Council, when not acting under Chapter 7, has dealt with the matter, and that was accepted by basically the membership at large. Now, that brings me actually to Chapter 7 action by the Council when it comes to humanitarian relief operations. In its Bruges 2003 session, the Institut de Droit International stated, quote, a refusal to accept a bona fide offer of humanitarian assistance might lead to a threat to international peace and security, end quote, and that obviously would then trigger the Council's competences under Chapter 7. What is important to note that in the view of the Institut de Droit International, it was not the refusal as such which did constitute a threat to the peace, but that it could lead to a threat to the peace, i.e. a situation under Article 39. And that is also reflected, I believe, in the Council's practice. Let us just look at Resolution 794 on Somalia, where the Council determined that the conflict in Somalia as such, quote, and now comes a very difficult word, exacerbated. So the conflict in Somalia, quote, exacerbated by the obstacles being created to the distribution of humanitarian assistance, constitutes a threat to international peace and security. Put otherwise, it was not the impediment to the relief operation that was considered to constitute the threat to peace and security under 39, but it was the conflict which was only then exacerbated by the by the impediments, okay? And that's mutatis the same approach the Council was taking actually with regard to the fight against piracy. Now, let's look at 2165 now, which is the most relevant recent practice. As Lance alluded to, well, there are Chapter 7 resolutions and there might be other binding resolutions. Now, what is then 2165? Is it a Chapter 7 resolution, even or only a hidden one? I believe it is, and I will show you why it is. First, 2165 refers to the situation in Syria to constitute a threat to peace and security in the region, end quote. This is regular practice, and we know that even threats to peace and security in the region under the Council's practice are situations within the meaning of 39. And what is really relevant, I believe, is OP 11 of the Security Council Resolution 2165. There the Council said, and I quote, the Council will take further measures in the event of non-compliance with this resolution, or Resolution 2139. It's important to note that within the Charter context, the very term measures is used exclusively in the context of or related to Chapter 7. Accordingly, the formula further measures implies, as used in 2165, that the Council had already, when adopting 2165, taken such measures. How else could it otherwise say it would take further measures? Okay? And that is confirmed by the practice of the Council in Resolution 2139, which also dealt with the Syrian crisis and which was not adopted under Chapter 7. There, in 2139, the Council said it would eventually take further steps, not further measures. So the Council clearly distinguishes whether it has already taken measures, as in 2165, or whether it has only taken steps, as in 2139. And again, this is further confirmed by 2118, which dealt with the chemical weapons in Syria. And there, in 2118, the Council decided to eventually, quote, impose measures under Chapter 7 of the Charter in case of non-compliance. So in 2118, it did not say it will take further measures, but it might eventually impose measures. So again, no Chapter 7 measures in 2118, none in 2139, but measures taken, Chapter 7 measures taken in 2165. And that is confirmed by statements made after the vote on 2165. And I will just refer you to the statement on its voting by Luxembourg. As you're certainly aware of, Luxembourg was one, despite its size, one of the main drafters and sponsors of the resolution. And the delegate of Luxembourg stated, quote, that this resolution and its provisions are based on the observation that the ongoing deterioration of the humanitarian situation threatens peace and security in the region that is our Chapter 7 based. Okay. So it's Chapter 7, and I will now skip the question, what if it was not Chapter 7 based, because it would still be binding under the Namibia holding of the ICJ and recent Security Council practice, but we can certainly come back to this during the discussion. Now, what does Security Council Resolution 2165 tells us about otherwise applicable norms of IHL? Or to put it in the words of Michael Bote, who unfortunately is not here.
He is.
Ah, sorry. Oh, Bote, I'm sorry. But you came late, didn't you?
I came as late as the others.
I truly apologize. So, to quote my esteemed colleague from Frankfurt, whether 2165 is constitutive in nature or declaratory in nature, that's the question. The Council starts by, quote, recalling that starvation of civilians as a method of combat is prohibited by international humanitarian law. Recalling. Starvation. So this is clearly declaratory. It's simply recalling. Mutatis mutandis, the same truth for the obligation to protect personnel engaged in humanitarian relief activities. There the Council says this is required by international humanitarian law. Protect personnel required by IHL. That's what the Council is saying. Then when it comes to the arbitrary withholding of consent, there the Council is already somewhat more nuanced. It's not confirming or noting that such withholding constitutes a violation of IHL. Rather, the Council notes that the United Nations Secretary General's view that such withholding of consent is a violation of IHL. It's not noting that it constitutes a violation, it notes the Secretary General's view that's a violation of IHL. So, and that might be telling on the views of the Council, whether we like it or not. And now, when it comes to the ability to bring in relief operation without the permission of the government, we have to remember that the permission granted by the Council under Chapter 7 is limited both ratione temporis and ratione personae. It's limited to a 100 days period, and it's limited to UN humanitarian agencies and their implementing partners. Had it really been merely declaratory, it would at least have been much more natural to extend the right to deliver assistance to all relevant actors, which they would then possess anyhow, and to not provide for a limited period of time only. And finally, again, there are two statements after the vote which are relevant and which are telling, I believe. And those are statements, again, by Luxembourg and the US. Two states probably which we would assume are most in favor of unhindered access, even without consent by the respective government. So the representative of Luxembourg stated after the adoption of 2165, quote, from now on the consent of the Syrian authorities will no longer be necessary, end quote. And the US representative clarified her country's position that, quote, by adopting that resolution, the Council has opened 4 crossings to UN humanitarian agencies and their implementing partners without the need for approval from the regime, end quote. By adopting that resolution. So both statements imply that had the resolution not been adopted, no such cross-border relief operations could have taken place. That brings me to my second last question, namely the question of common Article 1 to the Geneva Conventions, respectively Article 1 of Additional Protocol 1, and voting in the Council. As we are all aware, common Article 1 of the Geneva Conventions provide for the obligation not only to respect, but also to ensure respect of the obligations arising under the conventions. And as the famous commentary puts it, quote, ainsi encore, Si une puissance manque à ses obligations, les autres parties contractantes peuvent-elles et doivent-elles chercher à la ramener au respect de la Convention? End quote. And that was reiterated by the ICJ in its 2004 advisory opinion on the security wall or fence, in whatever you call it, in the occupied Palestinian territories, where the court found that, quote, all contracting parties to the four Geneva Conventions are, given common Article 1, under an obligation to ensure that the requirements of the instruments in question are complied with. And it's important to note that common Article 1, as well as Article 1 of AP1, refer to the obligations under the respective instruments in toto and not only to grave breaches. That is very important. However, it's also relevant to note that common Article 3 does not address the issue of humanitarian access, while AP2 does not contain a parallel obligation to common Article 1 or Article 1 of AP1. So I would submit that the treaty-based obligation to ensure respect does not arise concerning the issue of humanitarian access in non-international armed conflict, because the contracting parties to AP2 did not include a parallel provision to common Article 1, respectively to Article 1 of AP1 in AP2. So we might argue whether there's a customary law-based obligation to ensure respect of IHL, applicable to violations of IHL in non-international armed conflict. But be it as it be, at least where the obligation to ensure respect applies, I would submit to you that even states which are contracting parties to either the Geneva Conventions, and everybody is, and or AP1, and most of the members are, except the US, have, when voting on a draft resolution which would provide for access, humanitarian access, have to take the obligation to ensure respect for the Geneva Conventions and AP1 into account. And what would it mean? It would mean, to paraphrase the ICJ's holding in the Bosnian genocide case, the obligation of members of the Council and the Security Council at large to at least consider and eventually employ all means reasonably available so as to prevent the obligations of the relevant provisions of the Fourth Geneva Conventions when addressing humanitarian access. And it would entail, I would submit, an obligation for those permanent members, parties to the Conventions and AP1, to only veto a resolution aimed at ensuring respect for Article 71, AP1, or 59, Geneva 4, provided they believe that any such resolution is not able to pursue that goal, but not for any other political reasons, given that they would otherwise violate their obligation to prevent the occurrence of such violations of IHL, which they are an obligation to ensure that they would not happen. So I hope I've somewhat, in a rush, outlined some of the issues that might arise in the Council's practice, and I'm looking forward to your questions after the next speech. And I hope I was also in time.
You were marvelous and lucid. Thank you very much, Professor Dr. Zimmerman. Our third speaker is Daphne Schrager, who is a holder of an LLB and LLM from Tel Aviv University and a PhD from the Graduate Institute of International and Development Studies in Geneva. Between 1979 and 1985, she served in the international law branch of the Israeli Judge Advocate General's Unit. She joined the United Nations Office of Legal Affairs in 1989 and served as principal legal officer in the Office of the Legal Counsel until 2012. She's an author of various articles on the UN-based international and mixed tribunals, politics and justice, and the establishment of international tribunals, and the role of the Security Council, the applicability of international humanitarian law to peacekeeping operations, and the applicability of the laws of occupation to UN transitional administrations. Security Council is the promoter and enforcer of human rights and responsibility of international organizations. She has lectured at the Florence Academy of European Law, and as of 2012 is an adjunct lecturer at Tel Aviv and Hebrew University. Thank you, Daphne.
Thank you, Mr. Chairman. unlike my previous speakers, or the previous speakers who spoke about conditions of access, I would like to focus on the protective regime of a humanitarian agency, UNRWA or UN more generally, while already in the area in time of conflict. The most recent shelling of UNRWA premises, UNRWA schools, in the recent Operation Protective Edge was only the last or the latest in a series, and I should probably add lengthy series of similar shelling in the past. They were preceded by shelling of UNRWA premises, again in the Caslid operation, and in previous cases in southern Lebanon, in the Second Lebanon War, and in Operation Grapes of Wrath. And while all of these instances are probably very different from one another in the circumstances of the attack and in the place and time and the actors, there are nevertheless some disturbing commonalities between all these instances that require, in my view, a reconsideration of the regime which is applicable to UN premises. Some of these commonalities, just to mention the most important, of course, the most important, for most common feature is that in all these premises at the time of the attack, there were hundreds and sometimes thousands of civilians that sought refuge on UN premises. The evacuation of, or the presence of those civilians in UN premises was first of all known to the IDF authorities, and in some cases evacuation was done under orders or under instructions of the military authorities. In all cases, that was a reaction to opening of fire, either from Hezbollah in the north or Hamas in the case of Gaza. From the vicinity of the premise, and is arguably by the IDF sometimes from within, which was, I think, something that was denied by UNRWA at the time. In some of these cases, Israel has admitted its mistake, and in fewer still, it has agreed, without admitting liability, also to pay compensation either to the UN or to the families of the victims. So although these cases evidences a growing vulnerability of UN premises that are deployed in times in areas of conflict, the cases of Gaza and southern Lebanon are by no means unique. In fact, they are part of a more general trend of the last, I would say, 2 decades, where UN premises of whatever kind, or whatever mandate throughout the world, are becoming more and more vulnerable in times of armed conflict. At the same time, the tendency of civilian population fleeing to UN premises is equally a trend. It has begun more or less at the time of Rwanda in the 90s. It was in Bosnia and Herzegovina. It was in East Timor. And I think that as of the 2000s, it has been in almost every other country in Africa, in the DRC, in Sudan, Darfur, in the Central African Republic, and as we speak, probably in Sudan, in South Sudan, and I don't know at this moment, but certainly in the one moment of time, there were between 6,000 to 10,000 civilians dispersed or sheltered in various UN premises throughout the country. So this combination of particular vulnerability in times of conflict and the transformation, I would say, of UN premises almost to what I call centers of refuge to civilian population, coupled, of course, with the fact that this is an area of responsibility to protect, where the protection of civilian is part of a mandate which is incorporated in almost every peacekeeping operation in times of conflict. The combination of all these elements, in my view, suggests that this is really high time to reconsider the legal regime which is applicable to UN premises. Of course, I will focus on UNRWA, but I think that many of the things that I would say would really apply to all kinds of UN premises. The question of the protective regime of UN premises is first and foremost a question of the applicable regime. And it is either international humanitarian law that is applicable in armed conflict and is applicable obviously to the UN presence in as much as it applies to any presence in the geographical scope of applicability of international humanitarian law. But as far as the UN is concerned, there's also the United Nations law that is applicable in times of peace, obviously, but is equally applicable in times of war. And the question is, which of which applies to the protective regime of UN premises? So let's begin with what is actually applicable under international humanitarian law. Under international humanitarian law, UN premises, UNRWA, for our purposes, is protected as any other civilian object. There's nothing to indicate that they deserve or they get anything more. So although under international humanitarian law, from time to time, there's a sporadic protection to signs and emblems, and there is, of course, the 1994 Convention on Safety of UN Personnel, and in another convention, there is a particular obligation to take care of mines where you know that there is some presence of peacekeeping operation there. But fundamentally, UN premises are considered civilian objects. So from that perspective, they're governed by the usual rules in Article 52, Article 57. They cannot be attacked, obviously. The protection is not absolute. It can be, of course, abused, and when it is abused, there's no protection. But at the same time, the attacker force, if I can call it this way, is not released of its obligation to take precautionary measures. So all of the usual rules that are applicable to all civilian subjects, objects, are applicable to UN premises. And now I would like to take an issue, if I may, with another argument that has somehow infiltrated the debate. And the argument is the principle of inviolability. And this was a principle that was introduced by the previous Commission of Inquiry, Board of Inquiry on attacks against UNRWA premises, where one of the arguments was that UN premises are inviolable. And this is an absolute prohibition, which is, of course, applicable in times of peace and in times of war. And in other words, there is no military necessity argument that can release or permit, of course, the violation of this principle. The Board of Inquiry has repeated it verbatim in 3 or 4 places throughout the report. But in my view, what is more disconcerting is the fact that it was then adopted by the United Nations, by the Secretary General, and sometimes by the UN organs themselves. So Israel has violated the principle of inviolability, and therefore, of course, it's responsible for this attack. There was very little analysis of the international humanitarian law perspective with regard to those shellings. The only thing that the Commission of the Board of Inquiry didn't say is, where does this principle of inviolability come from? But of course, it comes from the 1946 Convention on Privileged Immunities of the United Nations, where under Article 3, if I'm not mistaken, UN premises are inviolable. But the meaning of inviolability under the convention is the non-consensual entrance of local authority into the premises. And that's it. In other words, and of course from that perspective, it is equally applicable in times of peace as in times of war. And rightly so, the principle is absolute from that perspective. And rightly, they argued that no military necessity can be a justification. And just if I can give an example, it will be unacceptable that Israel will enter without the consent of UNRWA premises to look for a Hamas activist, okay, in times of peace. But it will actually and equally be impossible and unacceptable and illegal for Israel to enter in times of war and to say there is a military necessity and I have to enter because, and so on and so forth. In both cases, the principle of inviolability, and I totally agree, is absolute, but only to that extent. In other words, the Privileged and Immunity Convention was not intended to replace international humanitarian law. It does not govern the conduct of a war. And therefore, I think that, with due respect, the Board of Inquiry had erred on the side of the protection. By no means I suggest that had they interpreted or analyzed the attacks under international humanitarian law, Israel would have come out more beautiful, but I only think that it would have been probably more correct. So if the principle of inviolability is not applicable, and the protection under IHL is insufficient, then what I think is necessary to do now is to consider granting UN premises a protective status of special or enhanced protection on a par or very similar or analogous to other objects, for example, like hospitals, artistic buildings, or architectural, and so on, all those particular group of sites that, unlike or more than civilian object, got a particular or special protection. that is on the level of a principle, of course, but then, of course, there's the level of technicalities. How do you give a special protection to UN premises? Of course, the best thing would have been done to do it through an international instrument, because this is how you progress in international humanitarian law. However, one has probably to admit that the prospects of now concluding an international convention on the protected status or special status to UN premises are probably very dim. And what, therefore, I think would be required, and it would be required for the UN first and foremost, because the UN, of course, is tackling it all over the world, but equally for Israel, to conclude a special agreement. And this special agreement, which has always been a tool, one most encouraged by the ICRC, to enhance compliance with international humanitarian law, even if they only reiterate what is already known in all other conventions. And this special protection will be an occasion for Israel and the United Nations to actually look closely at the applicable regime and all other aspects of UNRWA functioning. In other words, this special regime will include things that I think that UNRWA knows probably better than I, that already exist, like, for example, joint maps, better communication, a transformation of notification of all sorts or information that will go all ways. I think that many of these exist already, but I think that probably what does not exist is to ensure, as it is with regard to other special protected sites, that any decision on attack at or in the vicinity of UN premise should receive first, before the attack, it will be by decision of the high-level command, whether the highest or high, but anyway, not to leave it to the soldier in the field, because then, of course, we all said, well, oops, that was a mistake. I think that if this agreement will be negotiated, this will be a good time for both the UN and Israel, I think, to actually sit together and look at it at all its aspects. I think that it will be in the interest of the UN, because, as I said, this is truly a global problem. I think it certainly will be in the interest of Israel if it really wants to break the pattern of similar attacks in the future, with all the legal and financial and humanitarian and political implications that that might entail. But I think primarily it will be in the interest of all those hundreds and thousands that seek refuge on UN premises. Thank you.
Oh. Thank you, Daphne. Well, we actually are right on the button time-wise, so we can open up the floor to questions. Please.
Well, thank you very much for the most inspiring contributions. Being one of the authors of that letter, which some people at the UN do not seem to like, I have to say a few words.
Same for the ICRC, Michael.
Okay. I have to say a few words about the letter. What you heard from Lance is an example of what we meant by an overly cautious interpretation of the law. It is, of course, true that the major yardstick for action or inaction of UN organs is the Charter. And when claiming rights under different instruments of international law, including international humanitarian law, UN agencies have to respect the Charter if there is a difference. Now, what is striking me in some of the comments, your comment, but also in some other comments, is a selective use of the purposes of the United Nations. You mentioned sovereign equality. Yes, it's there. But you did not mention the goal of the UN to promote human rights. And I think these things go together, have to be accommodated. I'm really surprised hearing UN agents, not only you, certainly not, pleading an outdated concept of sovereignty after Secretary General of the United Nations, namely Kofi Annan, had pleaded for the need to redefine sovereignty, meaning that a claim of sovereignty may not be used by a state to cover its unwillingness or inability to ensure decent living conditions for the entire population. So that is my essential point. I'll leave it at that. For one exception, I'm not sure whether you implied that the letter requested United Nations agency to disregard the safety requirements for UN personnel. Certainly did not mean that.
Thank you, Michael. I see I'm going to be presiding over a somewhat hot and meritorious debate. Next question.
My question goes, I have two comments and two questions to Andreas, but do you allow me just to explain what, from an ICRC perspective, we also had an issue with the letter mentioned in the land speech and the reference made by Michael. It's not because this letter basically evidence a legal reading which is different from an ICRC perspective, but it's simply the fact that in the letter it is implied that the situation has been aggravated by a faulty legal interpretation, and I think we think that this letter detracts from the main issue, which is a political failure of addressing the conflict in Syria. So that's the main issue we have with the letter. Thank you, Michael. Just to Andreas, on the resolution 2165, I think we agree on the very ambiguous character of this resolution, which is quite comfortable for a legal advisor because it permits any kind of interpretation. In particular, the fact that this resolution would be a Chapter 7 resolution, even if it does not say that acting under the Chapter 7, and also it gives the possibility to interpret the content of the operational paragraph as getting rid of the necessary consent of the Syrian authority. And I think if you discuss with not the Syrian, but in particular the Russian representative, with which we have been in relationship, be it in New York and in Geneva, he would have had a completely different take than the one that you just presented, saying that it is not, absolutely not a Chapter 7 resolution, otherwise this resolution would have been vetoed by the Russian authorities, and that this resolution does not derogate from the necessity to get consent, because from the Russian perspective, consent could be implied through the notification process which is put in place by this resolution, even if it's really far-reaching, let's be frank, this kind of analysis. But just to come on the possibility to derogate to IHL through security resolution, don't you think that it would be better to have an explicit derogation in the Security Council rather than having something implicit in which we can, on which we can have whatever interpretation? So when it comes to derogation, as a legal advisor, don't you think that it would be better to have clearly an explicit derogation contained in the Security Council resolution? That's my first question. Second question relates to Common Article 1. You can imagine that we disagree with your line, in particular because we think that Common Article 1 and obligation to ensure respect for IHL not only applies in international armed conflict but also in non-international armed conflict because of the overarching nature of the obligation. And I would like to know a bit more the elaboration of your analysis in relation to the fact that Common Article 1 and its related obligation does not apply in situation of non-international armed conflict.
Thank you. Maybe we should get some responses from our three panelists.
Yeah. Okay. Thank you very much indeed. As to the first question, obviously, one always hopes that the Security Council should be more outspoken, should be clearer, and I would have loved if the Council would have said either way, there's no need for consent, and we just reiterate that there's no need for consent, or the Council would have said there is need for consent, but we set it aside, we derogate from the requirement of consent under relevant rules of IHL. Yes, but we all know, you know, there's this famous saying that you don't want to know how Wurst is being made, you know, because, and that's somewhat like for Security Council resolutions. Everybody puts something in, and then by the end something comes out, and then we are, as lawyers, we have to try to find what is in. That's obviously, I completely agree, and I also agree that coming back to Chapter 7 versus non-binding resolution, whether binding resolution outside Chapter 7, I think it was a good step in the Council's practice after 1990 to clearly say these are binding Chapter 7 measures and those are non-binding resolutions. I think it was a good step, and now ever since 2118 the Council is coming back and merging these two, you know, forms of acting without telling people is it binding, is it not binding, is it Chapter 7, not Chapter 7. So I think it's a step back, but that's due to the political, you know, the composition of the Council as it currently stands, and probably it will stand for quite some time, I'm afraid. Now, that was the first question. As to common Article 1, obviously, to be clear, common Article 1 applies to all obligations arising under the 4 Geneva Conventions. Thus, it applies to obligations arising under common Article 3. There's no doubt about that. So the obligations contained in common Article 3, which apply in non-international armed conflict, are clearly, you know, within the realm of the obligation to ensure respect under common Article 1. There's no doubt about that. But that's not what we're talking about. We're talking about the obligation, whether there's an obligation to ensure that relief obligations are not impediment, that there are no impediments to relief operations, right? So that's an obligation only arising under AP2. It's not an obligation arising under Common Article 3, okay? So, and then the only thing I'm saying, if we look at the structure of Common Article 1 on the one hand and the protocols, we realize there's an obligation to ensure respect in Common Article 1, and there's a specific provision on the obligation to ensure respect for the protocol, for AP1. There is a specific provision says you have to also ensure respect for the applicability of AP1. And when we read AP2, whether we like it or not, there is no parallel provision which says all parties to AP2 have an obligation to ensure respect for AP2. There is none in there. We know how it came about, but what does it tell us? If you say, well, it's already in Common Article 1, why is then, you know, the specific provision, why was the specific provision then introduced into AP1? It's redundant, it's completely redundant, it doesn't make sense. It should have been taken out too, but it was inserted. And therefore, if you take these three, you know, treaties, you know, one by one, it must mean that there is no obligation to ensure respect for the provisions of AP2 as such, as a matter of treaty law. There might be an obligation to ensure respect for the provisions of IHL in non-international armed conflict under customary international law. I completely agree, that's a different matter. We would then have to look into state practice and opinion juris, where I have to admit, if you look at the customary law study of the ICRC, state practice, and I mean state practice, not the practice of the ICRC as such, is relatively scarce. That's all I'm saying, you know.
Lance, just know that
Can I just bounce on this?
very quickly.
Yeah, just what do you do with the fact that the additional protocols are additional, so are supplementary in nature, and this has been interpreted by the ICRC as being subject to the general principle and provision of the Geneva Convention, including Common Article 1. That's one point. Second point, you refer to the distinction between additional Protocol 1 having in its Article 1 with a reference again to the obligation to respect and ensure respect. That's what put at the very last moment of the negotiation process, if my memory does not betray me, because initially it was not within the draft that was proposed by the ICRC, and it was including just because it was nice to repeat once again this obligation, and it was pretty clear for the delegates that it did exist previously. When it comes to the facts and to the explanation why it has not been included in additional Protocol 2, I have no clue. It could have been one of the provisions that have been clearly completely forgotten. I don't know, Michael, if you have any recollection of this issue. I might dive into the archives of the ICRC to try to formulate an answer to you in order just to explain why this provision is not reiterated.
I completely understand why it's not there. I know what the drafting history is all about, but we all know that the drafting history is only a subsidiary means of interpretation under the Vienna Convention. It's only a subsidiary means, and the structure. Yeah, I'm siding with Joram. The wording is clear. It's not there.
Yeah,
and
but
there's a specific provision in AP1. There's no provision in AP2. Does it make sense or does it not make sense? And it makes sense. But you know, don't get me wrong.
Maybe there's a Pakistani explanation.
I don't like it. What's that?
Maybe there's a Pakistani explanation.
Yes.
Okay.
So move on with customary law.
Lance, would you like to comment on these two questions?
Sure, just one. Thank you very much, Professor Volta. And I'm glad that you did intervene on that. I would have been very disappointed after the effort that I put in the 20 minutes discussions that you remained completely silent. Look, I think it was, certainly for us in a UN operational agency, it hit a mark and it had a lot of discussion. So if that was certainly part of the thinking, I think that was certainly effective. I think I would be with Tristan a little bit, that it's really that what I think working in the field and with Syria has marked me has been the incredible diplomatic failure. And especially when you saw the success relating to chemical weapons, but when it came to humanitarian access, let alone all the killings of the civilians, it was so difficult to get the community together. On the points that you make about the Charter, yes, of course, under the Charter, the purposes of human rights, it's something that within an operational agency that we work, often an assistance agency was not seen, didn't see itself as having any protection mandate. It's something that we've tried to work very closely with within our agency, and also within taking this encouragement from Kofi Annan, from Enlarger Freedom, for example, Louise Arbour's agenda for protection from OHCHR, to really try to be pushing forward the exercising of the protection mandate. I think it's very important to be bringing these two together. I don't think, though, that necessarily bringing, say, Article 55 of the Charter or Article 1, where the human rights references are, necessarily means that changes the processes by which you deliver access. But I do agree that it is something that we all need to respond to in humanitarian terms, to make sure that in whatever we're doing, we're pushing forward with all the purposes. And again, it was a little bit about when I was trying to explain about working within an operational agency. It's important to be credible as well. So when you saw and I will admit, a cautious approach from an operational agency to interpretation of the Charter, I also have in mind that often in my dealings with government officials on the ground, it's a very black letter, very nasty, brutal meetings that you can have. And so it's coming at it from that basis. But thank you very much for the intervention there.
May I just go very brief, I'm coming back to your question with a supplementary argument on your supplementary argument.
Additional.
Yeah, yes, because if we do a careful reading of the protocol, it says in Article 1, Paragraph 3 of the first protocol, this protocol which supplements the Geneva Convention. Completely right. But it says in Article 1, Paragraph 1 of AP2, this protocol which develops and supplements Article 3 common to the Geneva Convention. So it does not supplement the Geneva Conventions as such, but it supplements common Article 3.
Which is subject to common Article 1.
No, yeah, but if they had wanted to have Article 1 apply...
You said yeah. For me,
I have to exercise my chairmanship. No. I think we have a number of other questions that are ready to pop, and I invite you all to take the break, opportunity to do the break, and those who would like to sit can spend a good 10 minutes on this. Let's see who we got. May I ask Françoise first?
Two questions. First, a specific one for Dr. Schwager. I'm not suggesting you weren't thinking in these terms, but any special agreement need to remember that when you're dealing with special protection can be lost. Therefore, it would need to indicate the conditions that UN agencies have to fulfill to ensure protection. And it would be nice to know that they would always guarantee that there were no arms stored in any UN buildings. And more general, I think this is probably for Lance, because you've dared to mention those two words that, according to Europe, should not be spoken, human rights. But you've mentioned it in a blah blah kind of way. It's not your fault, because UN Charter is blah blah. But if we're much more concentrated, let us assume for the purposes of argument that the UN, dare I say, has human rights obligations. In which case, could you construct an argument to the effect that you have an obligation to deliver protection, including assistance, and a state can't, by an unlawful withholding, an unlawful arbitrary withholding of consent, prevent you from complying with your obligation here? Why don't, I mean, I realise that you're nervous about knock-on consequences of having human rights obligations, but why can more not be made of the detailed arguments in human rights law?
Could I ask for another question opportunity, please? Yes.
Thank you. Lance, I had a remark, which to some extent ties in with the point Daphne was making about inviolability. I feel a bit uncomfortable about what appears to me a bit of an artificial compartmentalization in your presentation between the rules of IHL and the other rules to which, from which UN agencies may benefit. And I feel that the law, the rules, the treaty laws of IHL are pretty clear in the provisions relating to humanitarian assistance as to who requires the consent. And I feel a bit uncomfortable about your attempts to sidestep them. And then my second point relates to your reliance on the 1946 Convention. And I feel that we need to break down the sequencing of relief operations, and that first we need to obtain the initial authorization to carry out relief operations. And I don't think that the 1946 Convention is relevant at that stage. You still need the green light to operate. I think it may take on a role at the next step, where parties that have authorized relief operations have a duty to allow and facilitate them. And it is at that stage of the process that you can start invoking privileges and immunities, the ones that you have referred to, but not at the initial step. And lots of comments on the resolutions that I won't raise now. Daphne, I was intrigued by the possibility of the special agreement, and another point to add on to Françoise is, wouldn't it also be necessary to reach some kinds of agreements with the other party to the conflict? Because obviously they also have a role to play.
Okay.
Okay, thank you. I have a question for Professor Zimmermann. It's a question that relates to, well, in your argument today, you made use of the term of measures in the resolution 2165, and you seem to be interpreting it in quite an extensive way. Now, looking at in your paper, you also referred to resolution 1973, and you are taking issue with Heike Montag's argument that the authorization to use all necessary means to protect civilians and civilian populated areas can also be meant to encompass proactive measures to enable the passage of humanitarian assistance. And in the paper, you're just saying that it seems somewhat far-fetched. So I was wondering why you would be arguing that if we know that there are members of the international community that deemed it not far-fetched to even fit regime change under this authorization to use all necessary means. So perhaps humanitarian assistance is slightly less than that.
Let me give an opportunity to respond to any of the panelists who wish. Daphne, would you like to start?
Okay, so I would like to take first your question, which of course echoed also in yours. Obviously, special agreements in this particular case would be extremely difficult. First of all, unlike a normal special agreement which is done between two states or two military forces, each of which can, if it wants to, ensure compliance. Okay? This is a case where, if I were to argue for the Israeli side, what I would like the UN to do is to ensure that there is no abuse within the premises and, by the way, also in the vicinity. The UNRWA in this particular case, argument would be that yes, I mean, we can ensure probably what happens now, but I mean, we have very little control of what happens in the vicinity. So I think this is the most difficult issue to resolve. But I would like to go to a previous understandings reached, I think it was 1996, after a Grapes of Wrath operation in Lebanon, where Israel did the same thing. There's understanding reached between Israel and almost everybody else other than those most directly concerned, namely Hezbollah. And Israel had committed not to attack these villages in these areas and civil and so on, and in response there will be no fire fired from. And I think that they were the other side, they were the UN, or they were the, not the UN, maybe the US, or there were other countries. Of course, Hezbollah was not there. So this is the most difficult issue that I think Israel will face if ever it comes about. But however, special agreement, as I said, even if it reiterates what has already been said, is extremely important, not only on the theory, but really on the process. And I think that if there is a decision that any firing will need a decision by the High Command, this I think will be a really important step forward. But I do not exclude the possibility that a special agreement will be a very tricky issue. Now, on the question of vulnerability, I raised this issue not as a consent to entrance, to access of humanitarian. This was in a very specific context of access. When I spoke about entrance, I meant entrance to the premises of the UN. And of course, not only it's like not correct because it doesn't belong there, but of course the difficulty in arguing that the principle of invulnerability, which is an absolute principle, absolute principle, but it is absolute only in that particular sense of the convention. What the Commission of Inquiry has done, what the Board of Inquiry has done in the case of UNRWA, they have taken this, they have imported it into the field which it doesn't belong, with the result that now, under international law, no target is absolutely protected, none, other than UN premises, where UN premises didn't get any special protection of any kind. So this is where I think there is a certain worry, and I think that this should be clarified. Again, under international humanitarian law, Israel may very well still be responsible, but at least the argument would be legally correct.
Lance, would you like to respond?
Yes, please. Okay, a few things. Françoise, yes, encouragement taken, and I think that there are possibilities for using the details of human rights law, and I should say that I'm not a fan of human rights blah blah, and it is technical, but there are uses that it can be made of. Interestingly, if you're looking for UN practice about applicability of human rights, there was a bit of a slip-up in one of our annual reports that went to the General Assembly in 2007, where at least UNRWA noted that it was subject to human rights obligations. So there's some state practice for you and Clapham and others, because he hadn't yet put that in his book, and I haven't told him. But I mean, we also have, as part of UNRWA's mandate, for example, specific references to human rights conventions. So it is part and parcel of certainly what should be used to support interventions, and definitely to be seeking consent. Manu, a few things on the 1946 convention. Last year I did a presentation here, also for Daphne. We have some different points of view, and I'd love to chat about them with you, probably in another context, but there will be a few points that I'll make. But I think in the breakdown of sequencing, yes, it is important, I think, to break down, first of all, that the United Nations has to get consent to be in to act in a certain state, and then the privileges and immunities kick in. But let's make this more precise. In Syria, when we're looking at cross-border humanitarian operations, when we're looking at the conflict started in March 2011. Well, let's not say armed conflict, but the unrest started March 2011, and somewhere during 2012 it became a NIAC. Now, what happened there was that prior to Resolution 2165, even 2139, 2014, there were many UN agencies already on the ground. UNHCR was there, WFP was there, UNRWA was there for our 2% of the population of Syria that we serve. There were already a lot of UN operations there. So while in principle your sequencing is important, what I would say is it's very important, and also I would suggest for you when you're writing about relief operations, and specifically for OCHA, when the UN takes such a lead, once the UN is there, I would suggest that these are additional frameworks that should be used, certainly in that sequencing. I don't want to say too much about special agreements, just They would certainly be difficult to negotiate. I think I would, something that I would like to explore, particularly because Daphne is a very senior colleague, ex-colleague from the UN, and been in the Office of the Legal Counsel and seen a whole lot of this stuff from the inside, whereas I'm in Jerusalem seeing things from a headquarters point of view, but still in the field. I would like to explore things with her a little bit more, but I think it's a little bit, as Andreas was saying, about what goes into the Wurst, or the sausage, and what comes out. I think that when we look after the incident in Jabalia, for example, which was the 30th of July, where there was a shelling, and the UN did come out saying that there was a serious violation, I would suggest that even though you've been on the inside for the Office of the Legal Counsel, particularly with the way that the General Assembly embraced the BOI's report, the GOI, and again, we can all discuss about the relevance of General Assembly resolutions, but they're not legally irrelevant at all. What they say has some bearing, particularly for the United Nations practice. But if we look at the statements after Jabalia, and I won't go into too many details here, but the US State Department came out with a very strong statement saying that what happened was unjustifiable, and they didn't know enough about what had happened on the facts, I think, to be judging about military objectives. So we think that that relates to inviolability of premises. And also the EU, when it was discussing about the shelling incidents, said that inviolability applies to all and at all times. So what I would be suggesting is, even though there may have been issues with the way that the BOI took a certain point of view, since its view is, it's not only the view of the BOI and it has made its way in to a certain extent, it is becoming more of part of the law than I would suggest that you've given it credit for. And perhaps that's because you know a little bit more about the inside work than looking at it from the outside. So that would be all that I would say at the moment. Thank you.
Okay. Thank you. I think we have a question here.
No,
and
I think...
question. Oh, sorry.
I think I had one specific question.
I'm sorry, Andreas.
And I don't want to shy away from it. Although it's somewhat technical, it relates us back to Resolution 1973-2011 on the protection of the Libyan population. Okay, and the question was, and there, in the preamble says the Council states, considering that the establishment of a ban on all flights in the airspace of the Libyan Arab Jamahiriya constitutes an important element for the protection of civilians as well as the safety of delivery of humanitarian assistance and the decisive step for the cessation of hostilities in Libya. So a ban on flights is linked to the safety of delivery of humanitarian assistance. Plus, the Council authorizes military action to protect civilians and civilian-populated areas under threat of attack in the Libyan Arab Jamahiriya. The question then is, just, I have to explain it. The question then is, would then the authorization to use military force also have enabled states, member states, to use military force to protect relief operations? That's the question. And I'm saying it's far-fetched, and the colleague is saying maybe it's not far-fetched. I think it is far-fetched. Why is it far-fetched? Because there are two authorizations to use military force in Resolution 1973. There is OP4, which authorizes military force to protect civilians in civilian-populated areas under threat of attack in the Libyan Arab Jamahiriya. And in OP8, there's an authorization to use military force to take all necessary means to enforce compliance with a ban on flights imposed, and so on. So there are two links. And humanitarian relief is only linked to flights. And therefore, you might only use military force to protect the no-fly zone. So if the Libyans have been flying, and that would have hindered humanitarian relief operations via airspace, then you could have used airspace. But you could have not military force, but you could have not used it under OP4, because that's a different mandate. It's a mandate. Plus, I'm not sure that creating impediments to relief operations could fall under the notion of threat of attack against civilians. As bad as it is, not delivering relief operations is not, in my understanding, an attack on the civilian. Attack is a term which is used in the Charter, which is used both in IHL and Article 44 of AP1 or 43. What?
51.
Oh, sorry.
Is,
Defensive and...
48.
48 And it's used for purpose of use ad bellum in the charter, obviously, so it's a very specific term. And I don't think that the withholding of relief operations can be subsumed under the term of a tax within the meaning of OP4 of Resolution 1973.
Okay, thank you, Andreas.
Sorry for being so technical.
We're getting a lot of good learning here.
Yes, thank you. Thank you to all panelists, I think, for great presentations. Just two questions, one to Professor Zimmermann and the other one to Professor Fraga. And they may be naive ones, but just on the 1265, just to ask, you mentioned that there was a practice of actually referring to acting under Chapter 7, recently at least. Why then hasn't this been the case, and why hasn't it been possible to refer to that in that particular resolution, and what would it, is there any relevance of the fact it hasn't been, because of particular reasons perhaps, for the interpretation of 1265? So that's one question. Professor Fraga, in terms of, you mentioned, I think, that the P&I Convention was not meant to replace international humanitarian. And building on what Professor Zimmermann already said, I would be interested in perhaps a more legalese analysis of how you arrive at that conclusion, particularly given the terms of the 46th Convention in relation to that the UN premises shall be inviolable. And you offered a specific interpretation. But then how do you actually arrive at it, for example, applying the instruments that you have under the Vienna Convention law of treaties and the rule of interpretation to the conclusion that then the 46th Convention needs to be rather narrowly construed in that context? Thank you.
Before I make my, could I see any remaining questions? Please indicate. We have, okay. Please ask your question now.
It's for Lance. I wanted to ask you in relation to the UN staff regulation, policy, and then other similar frameworks. Is there any distinguishment between protection measures that are accorded to international staff, national staff, contractors? So I'm particularly thinking about the situation in Gaza, and there was a little bit of a haze around when those protection measures were accorded. I'm curious if there was national law.
Okay. Lance first, and then Daphne, and then Andreas.
Okay, I get the short one. The duty of care applies to all of those who are UN officials, and they are both internationals and national staff. Now, the content of it will often depend on, of course, the circumstances, but also where they live. So, I mean, if the UN will not have, it will be very difficult to show a duty of care that has been breached, for example, if you have national staff who have always been living in a particular part and they are injured. If they've been injured as part of their official duty, then that's quite a different matter, and there is a duty of care there, and there is a relationship of a right of compensation from the UN in that kind of context. For contractors, it depends a little bit on whether you're talking about a contractor who's got a contractual relationship not as a staff member but almost working as an employee, or a company that you engage. I think from there it will be more a matter of contract, but there will still be a duty of care there that has to be interpreted in light of the particular contract. But I think to be clear, when the UN does, at least from my experience, when we engage with contractors, the contractors are always clear that you're delivering in a difficult environment. So your normal force majeure conditions, which would apply in, say, Switzerland, this is not what we expect a force majeure in Gaza or in Syria. These are difficult situations, but of course you are going to make sure that you try as hard as possible to get coordination and all the coordination that you would give to your international staff and your national staff so that you can actually deliver the aid, because once private contractors start getting shot doing things, it will be very expensive and it might even be impossible to keep on doing it.
I'm not so sure that I totally understood the question, okay? But let me try. I think that the problem that I tried to raise was not so much a question of restricted or more liberal interpretation of the principle of inviolability, okay? I wanted to know, where does this principle come from? It's not just principle of inviolability and everybody understands it, that's it. The only place where I think it must have come from is the Convention on Previous Immunities of the United Nations. And the article that deals with inviolability of premises is an article that has been interpreted in the big study of the Secretariat in 1967, which was added to in 1982, I think, okay? There is an explanation of what inviolability means. And throughout the years, it has been the practice, in particular the UN, Office of Legal Affairs, okay? Not that I was particularly involved, but it was the practice that the position of the UN has always been the principle is equally applicable in times of peace and in times of war. And there's a famous case, or not famous case, where in Afghanistan, for example, there was a UN convoy that crosses the dividing line or a checkpost, and then an American soldier start checking the car and the documents and whatever else, and then the UN said, no, you cannot do that because you cannot use a military necessity in order to violate the principle of inviolability. To that extent, I totally agree. My point was that this principle within this meaning is not applicable to regime of attacks or not attacks within the context of an armed conflict. So it's a question of applicability, not of interpretation, okay? And I think that it should be analyzed differently. Okay, in other words, is it a civilian object? Is it not? Is it has it been prudent? Has it been proportional? All of the usual guidelines and parameters of determining whether the attack was legal or not, but not importing from a totally different area and putting it there. And I know, of course, that you're right. Secretary General has adopted it. The General Assembly has adopted it. Sorry to say, but not because everybody has adopted it, it becomes true. There has never been any true legal analysis to explain where this principle is coming from. And of course, Israel is the only country to object, obviously because it is concerned with the consequences of this absolute principle, but then who cares if this is only Israel? So I think that there is a serious problem here, and again I'm saying, I think that under IHL probably Israel would have come out equally bad. Equally bad. That's not to say that it's nicer to say it's an absolute, but it's only to say it's legally incorrect to suggest that inviolability is the answer to what has happened to UNRWA and to other premises.
Andreas.
Maybe I didn't understand the question.
Maybe just if I can just follow up then, how do you actually arrive at the conclusion that the applicability then is narrow?
Well, again, it's not narrow in this. Take, for example, and there's the last thing that I'm going to say on it, the debate on IHL and human rights, okay? Nobody contests the fact, certainly not today, that both of them are applicable. But nobody will contest the fact that in each particular case, you really have to look and see what is the lex specialis, what is really applicable. All the more so, and this is human rights in IHL that really are applicable in the same because theoretically it makes sense. What you did here, you did a mélange between two areas that don't really belong, only because it happened to be a UN, and this is where you got it, in my view, mixed up. But I think that we should go exactly as we did in the debate on human rights in IHL, saying that both of them are equally applicable in time and in place, only that we have to look which one is more applicable than the other in any particular circumstance.
Okay. Andreas.
Yeah. Since we're so close to the coffee break, and mélange is very good when we talk about café, I will be short. The question was, why, if I understood it correctly, why was acting under Chapter 7 not included in 2165? Yeah. I think you have to tell the whole story. It started in 2118. 2118, that's the resolution on the Syrian chemical weapons. And I could say, easy, ask the Russians. The Russians insisted that there would be no mention of Chapter 7 in 2118. That was the conditio sine qua non to adopt a binding resolution. And then no mention of Chapter 7. So it was not, there was no reference. And just tell you a very short story. I once gave a speech on the margins of the 6th Committee in 2013 after 2118 had been adopted. And afterwards I had a coffee with the US legal advisor from the mission in New York and the head of the legal department from Moscow. And we chatted about 2118, and I said, this is not Chapter 7. And the US colleague said, yes, it is Chapter 7. We just don't say it, but is. What else could it be? And the Russian colleague said, no, it's not Chapter 7. And those were the two main sponsors of 2118. Okay? So, here we go. Now that brings us back, and that was kind of in 2165, it's just a warm-up of 2118. So why is there no reference to Chapter 7? Because it's perceived, politically speaking, as part of a slippery slope. You start with Chapter 7, then you go to 41, then you go to 42, they have military measures, and you know, that's a no-go for certain states. Whether it's good or bad, but it's a no-go for certain states. Now, and we've seen it before. We've seen it in 1701 with Lebanon, the broadening of the mandate of UNIFIL in Lebanon, where Lebanon at that time insisted that it would not be Chapter 7, saying, the situation in Lebanon, this is not a threat to international peace and security. Come on, give me a break. And that's why the mandate, while being very robust for UNIFIL, the broad UNIFIL mandate was not explicitly referred to as a Chapter 7 mandate. Okay? Now, we've seen other examples where the Council, for example, with regard to Iran, once said, acting under its special responsibilities for the maintenance of international peace and security. Acting under its special responsibilities for the maintenance of international peace and security? Oops. So what are the special responsibilities? They are general responsibilities and Chapter 7. These are the special responsibilities. So, you see, the Council is very innovative. The point is, if it's not a Chapter 7 resolution, then we have the ensuing question whether it can still be binding. And that's what the Council clarified in 2118 and now in 2165, saying this is binding under 27, under 25 of the Charter. And the Council, and that is interesting, thereby reiterated the famous Namibia holding of the ICJ from 71, which many people had thought it's a dead letter. I had thought the 71 Namibia advisory opinion had been overcome by the practice of the Council since the 1990s, because the Council so clearly distinguished between Chapter 7 and non-binding measures. But now, by a sudden, this old advisory opinion, whoops, here it is again. Yeah. Full stop, coffee.
Okay, thank you all very much for your attention, and thank you, panelists, and all for your